next I'm going to call on Riel Karmy Jones, King's Counsel, who is the current chair of the Criminal Bar Association. I'm very particularly pleased that you've been able to make it. I know you had to go off quite early, Riel, but thank you very much for making it. So over to you, please.
No, thank you very much for inviting me. As you say, I'm the chair of the Criminal Bar Association, and as such, I represent criminal barristers in England and Wales. And we have all been closely following the developments in Rajiv's case. It is worrying to us, as Baroness Chakrabarti has said, how polarizing this issue has become. And it is a concern that it is starting to feel like it's about the politics of the subject matter of the trial rather than the core principles of how a barrister represents his client. The CBA has received emails and messages from members with very different views, and I must recognize we represent them all. But I want to make it clear that I don't think that anyone, least of all Rajiv, disputes the principle that as barristers we are bound by the law and by rulings and orders made within the law by a trial judge. We have to remember that Rajiv has denied that he breached the judge's ruling deliberately or at all. And it's really important, as people liberally throw comment from the sidelines, it's important to remember and respect that this is still an unproven allegation against him. But our concern really comes from the number of tales of barristers across different parts of the country that we have heard of barristers changing their speeches or being told to change them, including in cases where no direction has been given by a judge. And that really can't be ignored because people at the criminal bar have become uncertain and scared of what they can and can't say, scared that somehow they might be at the end of a trial where they have faithfully represented their client, themselves be facing a charge of criminal contempt, and also through some unknown and novel procedure. Because what is really an enormous concern is how this is impacting how criminal barristers feel able to do their job and how well they do it and how well an innocent until proven guilty defendant is represented. Something that really troubles us here is the rather unusual process which has been followed, which Pete touched on in his opening comments. I'm not going to go through all the steps that may have been done or the things that could have been done so as to prevent this going so far. But as Pete Weatherby, King's Counsel, said at the outset, it's common for judges to stop speeches when they feel that they've digressed or gone too far. It's far from unusual to ask defense counsel in a case to withdraw what they've said in front of a jury, or even at that stage to give a direction to the jury. At the end of a speech, to give a really firm direction to a jury. It's also possible, if a heinous contempt has occurred, for the jury to be discharged, for another firm direction to be given during a summing up. And the usual expectation would be for a wasted costs order, perhaps, or a regulatory process, reporting the said barrister to the BSB, which might be thought to be far more proportionate than what has in fact followed. But the process followed has been a summary process, which is intrinsically designed to deal with things like where a defendant is swearing at a judge from the dock so that the judge can take swift action then and there to protect the integrity of an ongoing case. But in Rajiv's case, the trial is over. The offence complained of took place months ago. There's no urgency. So why not refer the case in the usual way to the Attorney General, who would be best placed to independently consider whether it's in the public interest to initiate proceedings for contempt of court. And so the issue has, over the last months, grown to be one of fundamental importance to the criminal bar, because it appears to be interfering with the barrister's role to represent their client's case fearlessly and as they consider appropriate, as long as they remain within the boundaries of the law. And in so doing, we suggest it's interfering with the rights of the citizen, the client, who's entitled to expect their barrister to present their case, their defence, warts and all, and to speak out in their favour against the accusations they face. And all this has the potential to lead to a significant loss of trust in the system, in the criminal justice system as a whole. Before I finish, I want to say something personal to Rajiv. Rajiv, we don't know each other very well, but we spent quite a while knocking around at the same cases, but on different sides, me a prosecutor, you a defender, when we were both much younger and very much more junior. I do remember poring over huge jury bundles and trying to agree them with you. And you have always been and always were an absolute gent. You were one of the nice ones, one of the good ones. And so it was no surprise when you were awarded silk a few years early for most criminal practitioners and a few years before me. It was well deserved then, and it is well deserved now. As you know, the Criminal Bar Association are following the case. We're going to continue to do so. And we're incredibly grateful to Garden Court and others for their engagement with us, for inviting us to be present at these important meetings and for keeping us informed. Now, a moment ago, the Bar Council's role was raised, and what their actions are in relation to the case was raised. And in fact, I spoke to Kirsty Brimlow earlier today, and just before the meeting convened, sent her a message because she'd said she was sad that she wasn't able to be here. Can I just say that she has, whilst we were speaking, sent me a message saying, asking me to read this from her. She says, as chair of the Bar Council, Kirsty Brimlow KC says, I'm in contact with Rajiv's leading counsel. I spoke in some detail with Joshua Rosenberg about the case on his podcast on May 15th, and I made a statement on May 13th following the Court of Appeal ruling. I and the Bar Council continue to follow the proceedings and the type of proceedings with concern. Sarah Kavanagh of the Bar Council is attending this meeting to observe. There will also be representatives of the Bar Council observing the hearing if it goes ahead on the 28th and 29th of July. There will also be representatives of the CBA at the hearing if it goes ahead on the 28th and 29th of July. So I can't say we look forward to seeing you there, but we will see you there.